Out of Order Gun Rights Podcast, episode 28.
Welcome to the Out of Order Podcast, your window into the firearms community, exploring those shaping the future of our rights and protecting our lifestyle, laws, legal cases, activism, and self-defense in a candid and honest podcast for our brothers and sisters in arms. Here's your host, James Kalita.
Thanks for tuning in to the Out of Order Gun Rights Podcast. Today's guest is Jay Factor. This is the third part of my interview with Jay, and we wind things up talking about the history of New Jersey gun law, and Jay throws a teaser in there at the end, so hopefully we'll have him back on to talk about the New Jersey gun smugglers pre-Revolutionary War. But head over to the show notes page, outoforderjameskalita.com/28, and sign up for the email list. Check out our sponsors. Consider becoming a Patreon and supporting the show, and find links to Jay's information over there. And now, here's Jay Factor.
So let's move. Let me just move you forward just really quick. The reason I say that priests helped us. Fast forward to 2008. Okay. Now, oddly enough, when I finally make it to Superior Court 2 years later, it was the week that the Heller decision comes out. I think the Heller decision came out 3 days before I went in front of Judge Kreisman. Well, you know how long the Heller decision is? I didn't have time to read and digest that. Anyway, I pull it up in my verbal. You know what Kreisman says to me? He says, the Second Amendment doesn't apply to the states through the 14th Amendment, so Heller's worthless. New Jersey allows me to keep guns, but they don't allow me to carry them. I swear to God, that's in the transcript. Wow. And I'm like, you got to be kidding me. Anyway, I get to the appeals court process, and I historically blow them out of the water. And they know I'm right, but they pull the same crap. There is a case, McDonald currently in the Supreme Court, which may be different, but as of right now, the Second Amendment doesn't apply to the states, and they cited Presser on that, which back in those days that the Presser, those guys were neo-Nazis trying to get a permit to march, and the government shut them down, so the court basically did an end around the First Amendment and used the Second Amendment to not get those guys a permit. So that was a really bad case for us. But the appellate court told me that I'm probably right. My history's probably right. There is a Second Amendment right to carry, but the 14th Amendment doesn't apply the Second Amendment to the state, so I lose. Man, was I mad! I was so mad. It had to be 2,000 hours into that brief. It was perfect. Anyway, let's fast forward. Remember I said to you, it was Priest that said the law division must decide 2C58-4 permits on a case-by-case basis? Mm-hmm. Okay. All the other cases, go back. Berinsky, go back to Wheeler. You could go read Drake. Any of the cases now, New Jersey prides itself. New Jersey actually thinks, these guys are so dumb. I don't think anybody's read Heller. These guys are so dumb that they actually pride themselves and write it in court briefs that the reason that 2C58-4, or the Sicardi rule, I should say the Sicardi rule, they try to pretend that the statute and the Sicardi rule are the same thing, which they're not, because a lot of judges don't know, and no judge wants to overturn a statute. So they keep saying it's constitutional because we decided on a case-by-case basis, and every applicant has the protection of that. Well, one day I'm reading Priest for the 900th time, and I see case-by-case, and I'm like, oh, my God, there is no way that New Jersey decides these permits on a case-by-case basis. I go back, and I actually caught it reading McDonald, so it had to be after 2010. I go back to McDonald, and I type in case hyphen, And on case hyphen, it comes up on page 3050, a citation of Heller. And the citation of Heller is, well, I'm going to give you the nutshell. You should go read it, though. It's on page 2821. The rights the Second Amendment is enumerated in the Constitution, and because it's enumerated in the Bill of Rights, and because it's enumerated in the Bill of Rights, it's not up to the government. Listen to this one. Even the third branch of government to decide on a case-by-case basis whether the right is really worth insisting upon. Basically, what Heller just said was, you can't approve or deny Second Amendment permit applications on a case-by-case basis. Well, what does New Jersey say they do? We approve or deny permits on a case-by-case basis. Sorry, fellas. The Supreme Court just threw that out. You now, post-Heller, have to decide your permits for 2C58-4 exactly like you determine them for 2C58-3. You're either fit, you're a good guy, fit element of society, or unfit. You're a criminal, and we don't have to give you the permit. And that's it. The only other disqualifier is going to be if you can't pass that shooting test. Huh. I'm going to assume everybody listening to your podcast can pass the shooting test.
Yeah. Yep.
Right?
Yep.
And so I think the original reason you got in touch with me is because Cheeseman brought up my name. Yeah. That's the Cheeseman case. The Cheeseman case has nothing to do with the Second Amendment. All the Cheeseman case is 3 parts. Part number 1, Heller says no more case-by-case determinations. Part number 2, New Jersey decides permits on a case-by-case determination. And basically what I did there for Mark, in my research, I just went through every court case in New Jersey, every one that was denied on a Sicardi rule, and did a word search on case-by-case basis and took out the sentence where they said, we decided this case properly on a case-by-case basis. So, Priest, Berinsky, Wheeler, Stratton, it's a whole bunch of them. They all brag that they decide their permit applications on a case-by-case basis. And then part 3 of the Cheeseman case is the only way to say the statute. And I think Mark brought this up in your podcast. If you open Black's Law Dictionary and you search justifiable and need, this is why I said if it was still just need would be illegal because need is on a case-by-case basis. So need varies with the situation of the person employing it. So it's automatically a case-by-case determination. Once they threw justifiable in there, all justifiable needs, if you open Black, justifiable means lawful. So all you have to put down on your permit is a lawful need, and need is synonymous with purpose. Go back through Heller. Go back through McDonald. Search the term lawful purpose. Used 1,000 times. Basically what they say is, yeah, you have a Second Amendment right to do pretty much whatever legal stuff you want, as long as what you're doing is for a lawful purpose. See, the state has confused a lawful purpose and tried to – they're still utilizing 1971 theory that public carry is dangerous, and therefore their reasoning is public safety, and therefore their reasoning it outweighs our lawful purpose. They can't do that anymore. Why? The same page I just told you, Heller 2821. The same page I just told you in McDonald, page 3050, and there's 50 of them now in the lower courts. McDonald on 3050, you cannot use interest balancing to take away Second Amendment rights. You can't say guns are dangerous. We all know guns are dangerous, except the Second Amendment was interest balancing by the people at the time. They've already done the interest balancing test, and the interest was it's more important to have a well-regulated, well-armed militia bearing arms than not. And we are going to offset any danger that we think to the public because, quite frankly, the Second Amendment, the well-regulated militia, is for the public safety. It's for the common defense. So the whole interest balancing argument was taken care of in 1793. It's not for New Jersey to go back and change it. There are things New Jersey can do. There are things they can do. If New Jersey wants to say they can, this one's debatable. I really don't think they can, but the way the laws read, it looks like it's too hard to fight it. They could say you have to carry concealed or you have to carry open. But that's pretty much it. They can't say much else. But basically, if you hold a 2C58-3, if you pass that, post Heller 2821, post McDonald page 3050, if you pass those qualifications, you qualify for a 2C58-4 in New Jersey. So that's what the Cheeseman-Gillard case is. It's not a challenge of the statute. We spend probably more paragraphs in justifiable need equals lawful purpose because the judges always want to save the statute. No judge wants to say the statute's unconstitutional. So our argument is we don't have a problem with the statute as long as the statute's read properly the way it was designed in 1966, that justifiable need is synonymous with lawful purpose. If we write down self-defense on the application, that's enough. Because by now, 40, 50 years after 1968, nobody's buying a gun that has no serial number on it. So in order to carry a gun in New Jersey, you have to have a 2C58-3. Yeah. You don't need anything else.
Yeah,
hold on 1 second. The whole reason for the need, remember, this goes back to 1924. The whole reason for the need in the 1924 law, which still carried forward, was because back in those days it was prohibition, and bootlegging and gangsters were prevalent. And sometimes they would catch these bootleggers and gangsters with concealed weapons, but they didn't have anything else to charge them on. And so they came up with this rule, because New York was pushing for it after the Sullivan Law. They came up with this rule about concealed weapons need a handgun carry permit so they could get the bootleggers and the organized criminals off the street and have something to arrest them for. That was why the law was made. It wasn't made to prevent Mark Cheeseman from getting a carry permit.
Right. Yeah, and it's I think you talked about something briefly a while back where it went from New Jersey to the rest of the country, and if it wasn't for this law getting passed in New Jersey in the 60s, we probably wouldn't have the 4473. We probably wouldn't have NICS. This all was born in New Jersey, and it was all born out of racism.
Well, it's I can tell you right now, the case in Massachusetts right now, that's our law. They got it from us, and I don't know if it's worth a lawyer looking into this, but there's a case in I think 1981 in Indiana. It's called Schubert v. DeBard. Indiana's code, Indiana's statute, reads exactly like our statute. It basically, when Indiana made its gun control laws, they used our gun control law as their guideline, and so did D.C. by the way. So did the Heller case. Those were our laws. Indiana has basically our 2C58-4 is written into their code. I think they call it IC 3508 or something, but it's the same thing. So this guy Schubert applies for a permit and writes self-defense on his application, and the police chief shoots him down and says it's too vague. Schubert's never been attacked. He doesn't need a handgun for self-defense. He denies the permit. It gets into the appeals court in Indiana. The Indiana appeals court says, look, the whole point of the Second Amendment is to protect the individual from the government disarming him. So if the statute reads that he needs that Schubert has to provide a need why he wants to carry the gun, and Schubert provides self-defense, under the Second Amendment, that's enough. That's a lawful purpose, and he doesn't need anything more than that. And the case has some other really good lines about how it would make the Second Amendment worthless if the police chief was allowed to do that, and how it would basically repeal the Second Amendment by disarming the people based on whether they needed the Second Amendment or not. But Schubert never went to the Supreme Court in Indiana. Why? Because the Supreme Court in Indiana said that's good law. We don't need to take any more cases. That's the way. That's a good one for anybody to read. You want to read where we're headed in the next 5 or, I'll tell you what, this Cheeseman-Gillard case is really good. And I don't personally see, with the evidence that we threw out there, how the appeals court can honestly come out on paper and say, you're wrong. We're still going to decide permits on a case-by-case basis. Now, the prosecutor had two chances at fighting the argument, so he didn't make this argument in Gillard, but he came back in Cheeseman and made the argument that the Second Amendment, the Heller case is an in-the-home case, and that you're not allowed to use case-by-case determinations on 2C58-3 permits, but that doesn't mean anything for 2C58-4 permits because that's outside the home. So how many times have you heard Heller's an in-the-home case in the last 10 years?
Oh, yeah. Yep.
Right?
Yep.
Heller is not an in-the-home case. As a matter of fact, if you go back and read the statutes, 2504, 2506, they say actually in the first page of Heller, this is a challenge to 3 separate statutes of the D.C. Code. You get more from reading Breyer and Stevens' dissent than you actually do from Heller itself, but they specify 2504 and 2506, maybe 2507. Heller's permit. Okay, so the decision in Heller is, assuming Dick Anthony Heller is not disqualified from his Second Amendment right, the district must issue him a permit, must allow him to register his handgun, and issue him a permit to carry it in his home. Okay? 2 different things. He gets to register it, that was his 2C58-3, and he gets a permit to carry it in his home. Except at the time, there was no 2C39-5 exemption that you can carry your 2C58-3 handgun in your home in D.C. The permit to carry it in the home at the time of Heller was a permit to carry it anywhere in the district. Write that down, anywhere in the district. Go to Heller. Type in word search anywhere in the district. It'll take you to Breyer's dissent, and Breyer specifically says, we're talking about a permit to carry it anywhere in the district. So it was a 2C58-4 that they issued him, or were required to issue him. It was a carry case. It was a carry case. It was a 2C58-4 case. It was a 2C58-3, and then it was the third part of the case was that, had to have the trigger lock or disassembled feature. Mm-hmm. That was the third part of the case. But there's 5 different spots, one in Breyer's dissent, one in Stevens' dissent, and 3 times in the main decision of Heller that they talk about the fact that it's not that it's a 3-part case: carry, register, and trigger lock. One more thing. Remember that I told you page 2821, mm-hmm. page 3050? Okay. Mm-hmm. There's 3 cases, Chandler, Reed, the third one escapes me right now, but it doesn't matter. You go back to page 2821 in Heller. What happens is Heller writes his decision, the Supreme Court majority writes the decision. Then the decision goes over to the dissenters. The dissenters are allowed to answer. So Breyer and Stevens write their dissent. Then their dissent goes back to the majority, and the majority gets to read the dissent, and then the majority gets to answer the dissent, and they start to split paragraphs and put in the main decision answers to the dissent. The whole interest balancing argument was proposed by Breyer in his dissent. So page 2821 is actually an answer to Breyer's interest balancing proposal, which Heller says you can't do. But you have to go up 3 pages. When the argument between Breyer and the majority starts, Scalia and Breyer, when the argument starts, Breyer is actually citing Reed and Chandler and the other handgun carry case that Heller had talked about earlier in his decision. It said, few laws in the nation's history, this is another good one to search, few laws in the nation's history are as strict as D.C.'s law. And of those few, most were struck down. And then it lists Chandler, Reed. God, I can't believe I can't remember the other ones. It's neither here nor there. But they were all carry cases, concealed carry cases, open carry cases, but they were all pretty much struck down, and the courts all said, the Second Amendment gives you the right to carry. You might have to follow the regulations of the state. You might not be able to carry concealed. You might have to carry open, but you have to be able to carry one way or another. It doesn't matter if the government says you can carry a long gun. If you want to carry a handgun, that's protected under Miller. So 2821 on Heller. McDonald, page 3050. There's a lot of lawyers who love to talk about law and want to get into all the lower court cases. There's really only one argument we need to beat New Jersey. New Jersey decides 2C58-4 permanent applications on a case-by-case basis, and Heller says you can't do that anymore. And that's why I think this guy Hardiman is, we're talking about this week in the news, Trump gets a pick for the Supreme Court, and on his list of 5 is Thomas Hardiman from the Third Circuit. Well, Hardiman wrote a scathing dissent in Drake. Very angry with New Jersey in Drake. Basically says New Jersey provided absolutely no evidence to support its claims. There's another case called Binder Up, Third Circuit case. Drake just gave a concurring opinion on. And in the concurring opinion, he cites Heller, page 2821, and says you can no longer decide cases on a case-by-case basis, Second Amendment cases on a case-by-case basis. If we get Hardiman in the Supreme Court, I guarantee you they take a case, whether it's the Massachusetts case or a California case or a New York case or a case that wants to put this to bed forever. He's angry that he lost in Drake. You go back and read his dissent, you'll see he's not happy.
Right.
So I think he's our guy. I'd love to see him get it. Everybody else wants Mike Lee. I don't know why you would take a sitting senator out of the Senate right now, but yeah, Hardiman's the way to go. What else you got for me?
I think that's it. I think I have enough for 2 episodes. I will split this somewhere in the middle. And
all right. Well, if you got to split it, let me give you one more thing real quick.
Okay.
If you want to call me back, the magazine ban, 10 rounds. The whole purpose of the Second Amendment was a check on the standing army. So in the debates of the Constitution, there was a committee of 11. George Mason was on the committee of 11. George Mason from Virginia, who wrote the Virginia Declaration of Rights, which has the original Second Amendment written in it. Mason was a younger guy at that time, 76, but he was involved there. I'm sorry, Madison. You know where Madison went to college?
No.
Princeton.
Oh.
Yeah, Witherspoon was his teacher. Witherspoon was an adamant Second Amendment guy. He said he didn't say the Second Amendment was for the security of a free state. When he wrote his version of the Second Amendment, he wrote it was to prevent against assassinations and Indian attacks. Anyway, long story short, George Mason is super sharp. He's Washington's go-to guy on the Fairfax County militia. Mason says, look, we almost lost the war because the states in the article under the Articles of Confederation were terrible and never sent their quota of militia, never sent ammunition, never sent weapons, never sent money to the feds, and we almost lost the war because of it. Mason puts together what are now known in selected draft law cases of Perpich v. Department of Defense as the militia clauses, which is Article 1, Section 8, Clauses 15 and 16. So basically that the federal government arms, disciplines the militia, and the states train them, right? Mm-hmm. And then the 15 is the government can call out the militia to prevent invasions, suppress insurrections, and there's one more thing they can call it out for. Anyway, Mason gets cold feet. The guy on the committee of 11 that introduced Mason's arming clause or militia clauses to the committee of the whole is our William Livingston, who's our governor. So William Livingston worked on the committee of 11 with Mason on this. And so when all this stuff gets proposed to the convention, it's our governor Livingston, who also had multiple thousands of letters back and forth with Washington about not being able to send money, not being able to send ammunition, not being able to send lead, not having enough militia with camp tents and cooking kettles. Mason gets cold feet and says, listen, we need to check against the standing army, but I think I gave too much, and tells a story about Sir William Keith that explained how they got rid of the militia in England in the early days, that they disused the militia and they let it sink gradually. And they didn't actually take away the people's guns. What they did is they made militia duty awful, that they made people go do militia duty for 60 days. They made them march to the other side of the island. They just made it awful until everybody said we don't want a militia, and then they got rid of the militia. And that's how they ended up disarming the people. It's a great story. But his story of why we need the Second Amendment, now this is a couple years before the Bill of Rights. I think Madison felt compelled to put that in for Mason. Mason never signed the Constitution. Madison really respected him. So the militia is a check on the standing army. And so it doesn't matter whether it's Elbridge Gerry or any of the other founders that were involved. They all said the militia is a check on the standing army. Why then does anybody think that the founding fathers would think that castrating the militia by giving them a 66% disadvantage against the standing army would be a good idea? Why, if the standing army is using 30-round magazines with a 10-round magazine, would the check on your standing army want to be at that disadvantage? It makes zero sense, right?
Right.
Then you got to fast forward to von Steuben's militia regulations of 1792, introduced by John Jay, President of Congress at the time, right before he was on the Supreme Court. Von Steuben's militia regulations were that everybody was armed the same. Every single person used the same gear. When he talks about it, he used the word troops. He never specifies, he doesn't use troops, he uses soldiers. He never specifies militia or the army. The 1792 militia regulations where every single person should be using the same equipment. Everyone should be using the same caliber. Everyone should be using the same rifle. Everyone should be wearing the same knapsack. Everyone should have the same kettle, because he wanted it to be interchangeable. If one of the problems in the Revolution was guys were using, 17 different caliber ball, fouling guns. Guys had different kind of black powder rifles. Some used cartridges, some had pans. It was awful.
Yep.
So they wanted everybody to be using the same weapon. Well, who has the power to arm the militia in Article 1, Section 8? The federal government. It was taken away. It was specifically taken away from the states because the states didn't do it, because it was unpopular to force people to have to go out. I'm going to use 2018 standards and buy an AR and 30-round magazines. Some people didn't want to do it. And if you were looking for votes to try and get elected for the state senate or the state assembly, or, for higher office in the federal government, it wasn't popular to tell people they had to buy a militia gun and they had to show up for militia duty 1 day every 3 months, 2 days every 3 months, whatever it was. So they took it out. They took it out of the state's responsibility specifically because the states blew it. So there's no way New Jersey has the authority to make a 10-round magazine limit just on the Constitution itself. And again, we go back to Heller. Our new Governor Murphy and his Attorney General Gruber Grinwall think that it's for the public safety. Well, it's not for the public safety. The militia of the Second Amendment is for the public safety, is for the common defense. So you wouldn't castrate your common defense against the standing army by making sure their magazines were 1/3 the capacity of the standing army's magazines. It makes no sense. So
Agreed.
I'm actually me and Cheeseman and Gillard are getting together, and we're going to file a second case against the magazines.
Oh, nice. All right. Yeah. Excellent.
Yeah. So that's I just gave you the basic history, paragraph 1 of where we're going. We're saying that New Jersey doesn't have the authority under the Constitution to limit the magazine ban, because under Miller, if you can use it, if it is usable with the well-regulated militia, then it gets covered under the Second Amendment. So that's where that's going to go. So I thought I'd throw that in there.
Yeah. And so, like, when I'm putting the show notes page together, the timeline, right? So 1920s, right? You can buy anything, anywhere, carry it anywhere, anytime in New Jersey. All right. And then
open.
Okay. And then it was we got laws in 1924 banning concealed because of the prohibition.
Oh, pre-24, you could do anything you wanted. At 24, no longer can carry concealed.
Okay. Or anything goes. All right. And then And then from 1924 to 1966, you can buy anything and carry anything open, but no carrying concealed.
Right.
All right.
And that was one of the problems that Sills came up against. Like somebody in like Bedminster, New Jersey, had a 30 millimeter anti-aircraft gun, and they used it to shoot down their neighbor's barn.
Really? That actually happened?
Yeah. And Sills had the anti-aircraft gun when he went to, every time he went to one of these meetings, whether he went to the House of Representatives or the Congress or the Senate or in the Assembly in New Jersey, he would always have the state police bring this thing with him to show why he needed this law, because people were using anti-aircraft guns to shoot at their neighbors.
Oh, yeah. All right. So, all right, 1924, 1966, no concealed. And then 1966.
Wait a minute now. 66 is important because in 66 you could still get a carry permit to carry concealed.
Okay.
Anyone could get it.
Oh, okay. So concealed with permit. With permit. And it was just an issue permit. It was
the same as a purchase permit. Everyone could get it as long as they pass the background check. Gotcha.
Okay. All right. And then, so 1966 to 1969. Well, I guess it's 1970. Everything's fine. And then 1970, that's when they start to see the permits not being renewed.
I don't have an exact date. It's very, very late 1969 or early 1970. But it's somewhere in November 69 to early 1970 is the change.
Okay.
So that's Sergeant Kloss.
Sergeant Kloss. All right.
For the state police.
All right. And then 1970 to 1991, you can't get it. It's always been the way it is now. Well, since 1970, where you won't get the permit without justifiable need, but they don't put it in.
In 71, the unwritten rule becomes Supreme Court precedent. It's not written in the code until 1991.
All right.
Now, can I just add one thing about the timeline? Yeah. That's why this New Jersey Register piece that is on Syndicate right now, that they're trying to put urgent necessity back in, is because the superintendent of state police talks about the letter of need, and I don't think he calls it that. He calls it the certification of need or something. But basically, he's looking for something other than what's on the application. 2C58-3, I don't know if it's D or E. No other conditions or requirements can be added to the form of the content of the permit. That used to be in 2C58-4 when it was 2A141-44. They took it out of the carry permit because it was redundant and they didn't need it. 2C58-3 and 2C58-4 are supposed to be read in harmony, as with 2C39-5E and 6. So they're not allowed to add anything to the permit application. Whatever's on the application, what is it? What do they call that? The SP66? Whatever's on the application is the only thing they're allowed to use. So by actually requiring that letter of need, they're actually violating this statute. That's important. That's super important. All right, so let's get back to your timeline. So you're at 1991.
Yep.
So then from 91 to today, the government, whether you're in Superior Court, the Appellate Court, I haven't seen any Supreme Court cases since Priest. Everyone's putting their reliance on the fact that it's good law based on Sicardi and Priest.
Okay.
Heller comes out in 2008, says no more case-by-case determinations. McDonald comes out in 2010, says the same thing, and applies the Second Amendment to New Jersey. Since 2010, case-by-case determinations, a.k.a. the Sicardi rule, off the table.
Okay. Thank you. I can't imagine. I've had all of these questions about where all of this came from for so many years, and
there's a reason you didn't know where it came from, because it was hidden. It was a scam. You were designed not to know.
Right.
It was designed. They didn't want people to be able to fight this. They just made up the assignment judge's rule. Complete violation of the Administrative Procedures Act. Could you imagine if New Jersey, if somebody tried to make a rule on abortion and did that? People would freak out. But we don't care about the Second Amendment.
Nope. Right. Well, Jay, I thank you so much for being on the show. And
all right, you let me know if you want to do another one. I got a couple more good ones. I have when the King of England put the no more buying lead, powder, and guns, and you needed a permit from the king or his privy council right before the Revolution, and Governor William Franklin's making that king's letter law in New Jersey, and then what the New Jersey men did to basically violate the law and become gun smugglers. I have all that information, and that's an hour in itself, and it's probably more exciting than talking about this.
That does sound like an excellent. I will. Okay. I will definitely call you on that one.
All right.
Thanks for listening to the Out of Order Gun Rights podcast. We will definitely have to have Jay back on to talk about how the Jersey people became gun smugglers. Can't wait for that interview. Please head over to the show notes page, Out of Order James Kalita /28, if I remembered how to count, and find links to our sponsors where you can sign up for the email list and links to Jay's information. We'll see you next time.